are up to an imprisonment of 10 years, go to the additional session judge, 7 years goes to the metropolitan magistrate, up to 3 years or fine goes to judicial magistrate first class, etc., etc. Now what I would like to go through is how, what are the stages of criminal trial in India. One important change and the departure from the British era of criminal trial is that in 1960, by the case called K.M. Nanavati versus State of Maharashtra, India decided to abolish the jury system. So since independence, since the constitution came in 1950 till the 1960, we had the jury trial system. But K.M. Nanavati, there are a lot of movies made about it, there are a lot of books about it. So if you one Google search away from this entire beautiful story of how the jury trial got abolished in India, the sum and substance of it is that there was a highly televised or highly published or written about trial of K.M. Nanavati, who was a naval officer who shot his wife using his service revolver. And how the entire trial was, influenced or written about, and therefore it came to a point where the Constitutional Court in India said, no, the ethos of criminal justice system is that it cannot be influenced. Everybody deserves the day in court, and therefore the jury system was abolished. Nonetheless, how does the trial take place in India is that we have something called the first information report. So any citizen goes to the nearest police station and files a report about a cognizable offense. Now, there are 3 separate, cogs in the wheels of criminal trial. One is the police, which does the investigation. One is the courts, which obviously do the trial, and then there are the people who are the accused and the victim and the families. Now, a first information report is filed, and there is an initial investigation that goes about, and what comes about at the end of it is called a charge sheet, which is essentially a document which says that based on, say, 13 eyewitnesses, 5 documentary evidences, 6 other evidences, the police has come to a conclusion that this is what a crime took place, that A walked into a room, A took a knife, A stabbed B, there was a blood splatter, there was the knife that was seized, B was seen running away from that scene. The charge sheet will have the entire story of the prosecution. It's India is also an adversarial system, I believe, like in Indonesia. And therefore, the charge sheet is the main document for the prosecution. Now, a charge sheet is filed, it goes to the court of the first instance, and there's a plea of guilt. The accused is read the charge sheet, explained the charge sheet, and then said that, okay, so you have done this, this, this. And therefore, the charges that are made out against you are, say, section 300, section 302, you're punishable with XYZ amount, and so on and so forth. And then the accused has the chance of either pleading guilty and taking whatever punishment is offered to him, or he goes to trial. And the first stage will be a framing of charges. The judge. There is a strict difference between what investigation and prosecution does and what the judiciary does. So till the style of filing of charge sheet is investigation and prosecution. Framing of charges, though may be repetitive, is the first step by the judiciary. It's called taking cognizance of the offense and framing of charges. Once framing of charges is done, there is an opening. I believe it's very similar. There'll be opening statement by the prosecution, there'll be opening statement by the defense, and there'll be evidences introduced, witnesses introduced, there'll be examination, cross-examination. The one peculiar thing in the Code of Criminal Procedure Code in India is that the accused does not always have the right to give his statement. A prosecution has to move a motion or an application. The accused has to move a motion or an application under section 313 of the CRPC to say that I want to be examined. And it's only then that his examination takes place. And as you can read, there's evidences of defense and cross-examination, there's final arguments, there's a scope for expert testimonies where, say, forensic experts or scientific experts, or now even today technology experts take their opinion. There is an examination, cross-examination. Then there is the delivery of judgment of trial. Once the judge decides that on the basis of evidences, these are the facts, and therefore these are the offenses made out, and therefore you're guilty of, say, murder, kidnapping, etc., etc. Once that happens, both the prosecution and the defense team have the ability to argue and sentence. If you go back, I'll just go back. Yeah, it says a lot of provisions in the Indian Penal Code say imprisonment up to 10 years, imprisonment up to 7 years, and imprisonment up to 3 years, or fine up to a certain amount. Now, there is an argument on sentencing that happens, and there are mitigating and aggravating situations and circumstances that are argued by both sides, saying that on the scale of 0 to 7, how do you punish a certain individual? And after a sentence on arguments is concluded, a judgment with the punishment is pronounced. And this is just a stage of trial. Post the stage of trial is appeal, then revision, then review. And I believe there are around 3 to 4 stages of appeal post the trial, which an accused or a suspect can avail, so that no right of his to fair trial is evaded or eroded. Now, prosecution system in India, as I said, is strictly differentiated from the judicial system and other elements. The investigation and prosecution is a permeable boundary per se, where the police and the prosecution system work hand in hand, but prosecution is the lawyer or the attorney for the state. Now, there is something called the director of prosecution. There are levels of prosecution according to the hierarchy of the courts, and the most common or the most important member is a public prosecutor, or which may be at the district court level or a high court level. Though there is no trial at the high court level, public prosecutors are important at the high court level, because most of the bail applications on the first stage are moved to the high court by writ or by an application through CRPC, etc. Therefore, that brings me to bail provisions. Now, in the Indian Penal Code, there are 2 types of offenses: bailable and non-bailable. The best way I understood it is a bailable offense is, say, a misdemeanor, and a non-bailable offense is a felony. Yet, both of them have the ability to garner bail, right? In India, there is a long constitutional and judicial convention and established practice that bail is first right and jail is exception. And we are very strong about that. Therefore, it has to have an extremely grave circumstance to incarcerate somebody at the stage of investigation. This is obviously pre-investigation and pre-conviction. This is investigation is pre-conviction, and post-judgment is post-conviction. And yet, at both stages, there are avenues to bail. The first one is called, the colloquial term is anticipatory bail, which the CRPC defines as bail apprehending arrest. The core argument that is put forth in such applications is that, hey, listen, there is an FIR against me. You haven't filed a charge sheet yet. It's under investigation. Why should I be incarcerated then? And therefore, there's a bail apprehending arrest. Now, post-conviction, what happens is there are 2-3 types of bail. One of the most important is called suspension of sentence, which is being on bail or having your sentence suspended while you're in appeal. Post conviction, you have the ability to go to appeal at the High Court, at the Supreme Court. So if your appeal is pending. Now, this is important in India because unfortunately, we have an extremely high docket of cases which are pending, especially criminal appeals. And therefore, if if there are procedural irregularities in the conviction judgment, if there's a change in law, if there is a new jurisprudence, if there's a change in if there's a new precedent that comes out that helps the accused, there is a strong ground of appeal, and therefore there is no requirement of an incarceration. Again, bail is the right and jail is the exception. It draws from that, and therefore suspension of sentence is an important aspect in an appellate stage. So I get to deal a lot with the High Court and Supreme Court level, obviously, and therefore suspension of sentence is something that I see fairly common. Excuse me. Right, but there are apart from bailable and non-bailable, even in case of non-bailable offenses, the CRPC talks about when bail can be given. So it precariously uses the word may and shall, which is again defined in the Indian Evidence Act. For example, offenses, it has to do with gravity and mitigating and other circumstances. So if your offense is punishable with death, he may be admitted to bail. If there's a reasonable ground for guilt, accused may be admitted. What if there is an existence of reasonable grounds to their accused shall not be released? That is fairly certain. Point 5 will be if there is no absence of reasonable grounds, or if the trial is not concluded within 60 days, there he shall be accused. Point number 6 is called what nowadays we call default bail. It draws from the principle that trial is a matter of right, fair trial is a matter of right, flows from the Constitution, and therefore the prosecution and the investigation cannot file an FIR, arrest an accused, and keep him incarcerated if the trial is not concluded in 60 days or the investigation is not completed in 90 days. The accused has a fundamental right, statutory right, to move to get bail. Now, I think Dr. Qadiruddin also touched upon this a little bit. There are some pre-trial rights and rights during trial and after trial. One of the most important, and these flow from statutory as well as constitutional principles. The accused has the right to know the accusations. So there is nothing so-called like how Miranda rights exists in the United States, but we have something called right to know about their accusations, right against self-incarceration. Even say the truth test or the truth serum only has a corroborative value and is not a confessional value in India. This is established in the case of Selvi versus State of Tamil Nadu in 2009, I believe. There's a right against double jeopardy. There cannot, especially in criminal trial, there cannot be an ex post facto law against which you can be prosecuted. As I said, bail is the right of the accused. In India, there are a few rights that flow from the Constitution, some which flow from the statute, and a lot of rights flow from judicial precedent. Supreme Court of India has been at the forefront and the sentinel of rights and justice in the country, and therefore say something like a right to legal aid, the right to fair and speedy trial, and the right to dignity during trial is something that is established by judicial precedent. I'll cover that in the next 2 slides. During and after trial, there has to be transparency by the prosecution. You cannot hide evidences. You cannot hide anything incriminating against the accused, and everything has to be transparent. The accused has to be present during trial. One of the key important rights is once the accused is arrested, within 24 hours, he or she has to be presented before a magistrate, which is the court of first instance. Within 24 hours, has to undergo a medical examination, and then the magistrate decides whether there is an incarceration necessary, whether arrest is necessary for investigation, whether there has to be a police custody, whether there has to be a judicial custody, and therefore the right of the accused in the first 24 hours is also recognized. As I said, there has to be transparency. There is a right to get documents. The touchstone of criminal jurisprudence around the world is the right to be presumed innocent until proven guilty. Once a judgment has been given, the accused has a right to a copy of the judgment. It's provided free of charge and has to be provided free of charge by the court pronouncing or deciding the trial, and therefore there is a right to appeal. Just because an accused is incarcerated, he can or she cannot be denied of the right to appeal the judgment. As I said, Article 21 of the Constitution of India is one of the most important provisions from the Constitution, which says the right to life. Right to life has been interpreted by various courts